Social Security Administration's Office of Disability Adjudication and Review in Alexandria. He prepares cases and writes legally defensible decisions for his judge, dealing with all cases all over the country. Before coming to Northern Virginia, he was in the Charlottesville hearing office. He has also served on various capacities in the ABA Young Lawyers Division, including as a delegate representing Virginia to the YLD Assembly, as a committee chair for the Public Utilities and Aviation Committees, a liaison to other sections, and a director and coordinator in the Executive Cabinet. Locally, he serves on the Board of Governors for the Virginia State Bar Young Lawyers Conference, where he oversees this conference right here. So Chris has actually been the guy in charge of putting together this professional development conference. What you guys did not see, which you don't really need to see, is all the running around Chris has had to do, and especially with me, with some of the problems that we've encountered. He's been there, and also he and I had to step out of the room to, deal with the problems, or not so problems, the schedule changes that are occurring this afternoon. By the way, the schedule's back to what it was, so good news. You guys get to see Adam today. He also expanded the YLC social media footprint from a Facebook group to include Twitter, Google+, LinkedIn, YouTube, Instagram, Tumblr, all of which you can follow the YLC online if you so choose. It's a great opportunity, and you get to stay abreast of everything that's going on. He runs the Professional Development Series, a weekly release of videos dedicated to training new lawyers on basic tasks of lawyering, viewable on the YouTube channel. And if you actually follow everyone on follow the YLC on social media, you totally see those. They're great videos. He also won the Edwin Burnett Young Lawyers of the Year Award in 2013. He graduated from Appalachian School of Law in Grundy, where he served as its Alumni Association president in 2008 to 2009, starting that social media presence. This guy's totally qualified to talk about social media. He's also a very proud graduate of the best university in the state of Virginia, James Madison University, and is also married to Brittany, right there. Hi, Brittany. So without further ado, here's Chris.
And you thought I was just the elevator guy. Wow. Thank you very much, Melissa. Let's see. Have you ever had that moment when you saw that post that made you shudder? Something was misspelled. Something might have been disclosed a little bit early or improperly. Or someone posted something that is just asinine. It happens more often than you think. I guarantee you that as a lawyer, when I see something like that, I wonder when the lawsuits will start falling. I mean, that's more work for people like us, right? Isn't that great? I know, I kid a little bit. But I only kid if you have good social media policies and you thought out all the legal issues with your social media policies. Today I'm going to explore some areas you may want to examine with your clients, or maybe the insurance carriers if you're dealing with your own law firms, to make sure your policies, and more important, your actions keep you out of trouble. First of all, before I go on, let me ask you this. How many of you here, and we're going to stretch our arms a little bit, how many of you here have a Facebook account? Okay, a lot of people. Twitter? Not as many of you. All right. And LinkedIn? Good, good. Google Plus? Okay, a few of you. I'll get through this eventually. YouTube? You okay? Pinterest. How many of you have Pinterest? A few of you have Pinterest. Okay, that's good to know. Instagram? Okay, more of you, and Tumblr. All right, I went through that just to make sure how technical I need to get with explaining how platforms work, especially with what we're dealing with. So as you see here, I have to plug the social media channels. We had our website. If you Google the letters VSBYLC, you can you're going to get these website and these social media channels as your top results. So if you can't remember all that, just Google VSBYLC. So just a couple of things before I begin. Yes, I work for the federal government, but the remarks I'm going to make today are not reflective of those of my employer, SSA, the U.S. government, the VSB, the Virginia State Bar, or the Young Lawyers Conference. Second, please don't mistake what I'm going to say as legal advice. Legal advice is something that we all provide on a case-by-case basis and change from circumstance to circumstance. You'll hear me say sometimes throughout the presentation, this is something you need to explore with your clients. I always say that because I don't know how your clients operate. Remember, this is for informational purposes only. Feel free to ask questions on general topics here. However, I cannot give specialized legal advice because in any case, it's going to be really bad. So just keep that in mind. So let's think about the goal. The goal of all this is to keep your clients out of trouble. Would you say that's a good goal? Yeah. First of all, state to your clients that there will be conflicts in the future. That stuff's going to happen. Employees are going to leave. Customers may get annoyed at promotions. A competitor may think your client's going out of bounds. They probably will think your client's going out of bounds at some point. Or a government regulator may not like what you're doing. They may even get sued. If their act is not together, then you're going to be in for a wild ride. A really wild ride. Explain it like this to your clients. Social media, how we commonly think of it, has been around for about 15 years. Mass use of social media, 10 to 12 years. Organizational use, business use of social media, probably 6 to 8 years. Now think of that against the common law. We reference cases back to, say, the 1950s and the 1960s common. So the basic thought is, there's probably not going to be a case on point, specifically as of right now, in 2014, to address a potential issue that your client may be facing. As a matter of fact, we're getting ready to have one case in front of the Supreme Court coming up this term. I don't know how many of you have heard of the Alanis case. Those of you who are graduates of the University of Virginia may know this because one of your legal clinics is involved in this case heavily. The question's going to be whether threatening remarks, well, okay, not necessarily threatening remarks, vaguely threatening remarks, passive-aggressive threatening remarks on social media are protected speech. But to get back on subject, here's a good guidepost. Let's not risk this. Let's not be the test case. I know your PR people may think, oh, publicity, all publicity is good publicity. But let's face it, when you're talking about being the blank case, the Alanis case, the whatever your organization is case, that's not necessarily going to yield more business for your clients. Here's another good tip. A website's term of use will not protect you. It will always protect them. Therefore, you have to protect your clients and your employees who are working on behalf of your organization in social media as part of your duties. This means out with it. Incorporate by reference. Do you not want posts that are vulgar? Do you have a decency policy, a sexual harassment policy, or a commitment to diversity statement? State those in your social media policy. Do you not want insider information on social media? Incorporate your insider information and trading policies by reference. That means stating posts in violation of our insider trading policy, sexual harassment policy, etc., will be removed. That's really all you need to do. Here are some resources I consulted for this presentation today, and these sites will generally back my remarks. If you're interested in keeping up to date with social media law, follow these first two blogs created by some of the large firms in the country. They're usually on top of the latest litigation in the courts and administrative law rulings in federal agencies and in state agencies in places such as California, where a lot of these companies are headquartered. Some of you may have state or local governments as clients. The National Association of State Chief Information Officers has a fantastic and comprehensive guide that'll take care of social media issues from a government viewpoint. Frankly, in my opinion, it is a must-read, even if you have clients in the private sector. It gives great ideas. Finally, if you're not into reading, I totally understand, there's something called the Top Rank Law Blog. That would be the last link here on the bottom. They covered a social media law panel in St. Paul, Minnesota about a year ago. And they give you a few takeaways to remember. They give you 11 takeaways to remember. I'll cover some of these throughout today's presentation, so reading this will reinforce the lessons that you all will be learning today. I know this is a legal presentation, but sometimes you have to step back and consider the non-legal stuff. A well-thought-out social media strategy helps plan your social media policy. The strategy and the policy should align if you want to be effective with your communications. Do you know how to use these platforms? No. This is how you tweet and Twitter. But saying things such as, our company, our organization uses Twitter to do X. We use Google Plus to do Y. For example, would Twitter be a good forum for customer service complaints? You can shake your heads out of the way. Yeah, exactly. I'm hearing some laughs. At 140 character limit, if you're long-winded and you have a complaint, well, that's probably not going to work. Think of it like this. Most of the users of your social media pages are going to know how to use social media, but they're not going to know how the social media aligns with the overall business or organization communication strategy. Do they have a complaint, a compliment? Make sure you have compliments on there too, or a question. If you disclose that strategy on how you use your social media, the user has an idea where to go. The right people are looking at the particular post, and the less likely your client will have to moderate a post, making everyone happy. Similarly, another thing to think about, the number of accounts and who can speak for your client is something else you have to account for. I know fewer accounts is less exposure, but the upside is fewer time, fewer people, fewer resources in monitoring everything, meaning a more nimble operation. On the other hand, I realize more accounts means more flexibility on how you may express yourself, but you open yourself up to greater liability as you have to monitor each account carefully. So it really depends on the size of the organization you're dealing with. A larger organization may be able to have the resources to monitor more social media accounts. But if you're a 20, 30 person operation, I don't know if I'd recommend having everybody with a Twitter account, especially if you have to monitor and devote time to it, if that's really a good idea. So my recommendation is this: as few as possible. Meaning, tell your client to ask themselves, what brands need promotion? Dividing by brand may determine what needs promotion, and that is what people know you for, by your brands. As few as possible allows you to keep your message consistent and keep the liability down. Name the people who speak for your organization and limit the access to just those people. In this day of quick messaging, you need to be on your game. Legally, I can only imagine that legal responsibilities will increase as the law evolves. That multiplies with a large number of Twitter accounts, Instagram accounts, Facebook accounts, whatever accounts employees may be running on your behalf. You may get regular shocks and new responsibility with all these court rulings. That means you're draining department budgets, you're getting lawyers aggravated, and you can have confusing mistakes which could lead to, guess what, more work for people like us. Maybe that's not such a bad thing for the present company in the room. Make sure also you make your social media policies prominent, integrating them with employment contracts, employee handbooks, company procedures, department manuals, whatever is appropriate. A major part of our lives as human beings goes through this medium. Similarly, your organization's name may appear as the second line of your employees' personal profiles. I don't know how many of you have seen that. You highlight over somebody's profile, somebody's name on Facebook, and you'll see name, maybe where they went to school or who they work for. That's something to think about too. So also, sites, most prominently YouTube, Google+, are now requiring you to have accounts to identify yourselves as commenting on these sites. So you may want to have something in your employment agreements about behavior on social media. I can't tell you how many times I've seen in comment sections, John Doe, manager at ABC Corporation, with an all caps filled hate rant on the tirade on an issue of the day. Warn your employees about that. Tell them that's. If they're going to comment with your organization name under it, they may place themselves in trouble and give your clients a lot of headache. We've seen many bad posts that cause social media professionals heartburns, and they could create major threats to your clients, your bosses, or their employees' livelihoods. As a reaction, I would hope many companies are evaluating their social media policies regularly. So if you're on counsel for a company, urge them to do a regular review. I would recommend once a year, or when they're integrating new social media platforms, and for example, they want to start a Tumblr account, they need to evaluate their policies to see if their usage of Tumblr is going to work with how the policies are written properly. Well, surprise, I have some examples. I know I've been talking for a little while and been giving you a lot of abstract thinking. Well, take a look at this. Walmart's social media policy. They have a pretty good policy that mixes strategy and policy and communicates it to the users. They provide guidance here in this little example on where to go if somebody has a comment. So a customer service complaint, you go to the feedback tab on their Facebook profile. Or you can always email or call their phone number. So that's stating right up front, don't leave your customer service complaints right here on this site. Or we could do it like the Air Force. I know. They tend to account for everything. I mean, that's very good. Something this comprehensive explains exactly how they do things. So they have little things, they classify them: trolls, ragers, misguided, unhappy customers, yes, no, when to monitor, when to fix the facts, when to restore things, when to share the success, when, oh yes, they have let the post stand here on the far left side. And yeah, it's pretty complex, but this gives a good idea for your clients how to do the job quickly and efficiently, and maybe how to evaluate a certain type of post. I know this is a little thin, but when I redo the video, I'll make sure this is a little more prominent. Here we have Best Buy. Best Buy has a very, I picked this as a great example because it incorporates by reference. They talk about here their customer information, IT policies, their code of business ethics, confidentiality, their policies against harassment, sexual harassment, inappropriate conduct, and securities trading. So definitely something I highly recommend. If you want more examples, there is a website that links and collects social media policies from around the world, from governments, from private organizations, large, small, whatever. That's your site you should go to, socialmediagovernance.com/policies. Let's dive into this a little bit further. Let's talk about ownership. 3 big issues you need to clarify in those policies. Who owns the content? Is the content copyrighted? And who owns the accounts? That stuff creates some big fights. First of all, consider who owns everything and set this out for liability reasons, as there are going to be things that you will want to disown. For example, comments on your social media pages. You'll want to disown those. As we know, in the past ruling about a few years back, it's common knowledge that social media administrators are responsible for the comments that come onto their page and to moderate them. That is the current law, but of course we could always see a challenge. But I go on a tangent. If you want to claim ownership of something someone else does on your behalf, something that you want to have, you must get permission. Have a form ready to go, just like we did today for our speakers, for them to be recorded on our nice little camera here. These waiver forms are easy to reciprocate. They're easy to replicate, they're easy to do. Make sure also to independently verify copyright, especially with written pieces. Tell your clients a quick and simple way to do that is to take the first line of text and Google it. If that shows up on any other website, you may have a copyright issue that you want to explore a little bit further. So it really is a simple thing to do. If there's no match, well, you're fine. If there is a match, well, you need to have a little chat. Also, make sure you have clear guidelines in your policies about who owns what social media accounts and how those accounts are used. More on that later. So I mentioned copyright a second ago. 2 thoughts you have to consider. You can't do it in real life. Put money on it. You probably can't do it on social media. The courts have not really seen any difference between social media and other types of media that drastically alter your rights and responsibilities. Maybe that changes in Alanis coming up later this year. But on the spirit of our don't get in trouble theme, think in terms of real life. Would you do something like that to their face? Just think, would you do something to their face? Second thought is, stuff goes viral, right? Stuff goes viral. If you do something wrong and it is weird, expect people to see it. If you have a lot of enemies, or if you have a client that has a lot of enemies, expect people to see it. If you've not gotten my point already, you'll need to monitor for copyright infringement. The sad thing about our world is that social media properties can create liabilities in a flash. For example, Pinterest, as we discussed at the social media panel in St. Paul. Pinterest in its user agreement, I'll give you a little explanation. I'll step back here and talk about Pinterest. Pinterest is basically bulletin boards where people can post things on their website, stuff they like. Photos, flowcharts, websites, advice, whatever they like. Pinterest in its user agreement states you retain the copyright to your pins. So you are responsible for the copyright of everything. I know, doesn't that sound great? You know, stuff that you create, you don't have to give away the copyright. But think about this. Your bulletin boards, or your client's bulletin boards, are probably full of content that comes from outside your organization. Make sure you are aware of what is yours and what's not. You may even mark on the caption of your pins who made the content. Maybe doing it through the HT hat tip acronym or something like that. Most people will love that you pin them on your boards, but there's always those who don't. You know, 2 or 3 people may be like, oh, that's mine. If they ask, just take it down. Don't ask why. They'll eventually tell you if it gets to that way. While this concern may be minor, acknowledging the author and stating, this is not something we made, but something we really like. We highly recommend you see this. Should alert the user to exactly what your intention is. If you really like someone else's content, and this can go all social media platforms, here are a few things you should do to make it look like it's not yours, particularly in blogs. Use short quotes indented. I know some sites have the ability to make quotes and put them in a different color highlight. I highly recommend that. This is still the standard notation in writing to show that you are quoting someone. The longer a passage goes, the more likely a reader will lose sight that someone else is saying that instead of you. Of course, ask permission, credit profusely, and don't forget to use the HT hat tip. Everybody knows what hat tip is, right? Yes? No? Oh, okay, good enough. All right. Hat tip means I'm giving credit to this person. I know it's internet speak, but hat tip means I'm giving a hat tip to whoever made a certain piece. Let's talk a little bit about photos and video. There are a few minor wrinkles to this, but think about this. The behavior I said to use for Pinterest generally applies to taking photos and posting them on Instagram, or using video and posting it onto YouTube. Yes, the signed consents are better and more airtight. If you're shooting a video and getting direct comments from somebody, definitely do that. Definitely get that consent. And if you're interested in seeing what a consent looks like, flag me anytime today. I'll show you an example on the registration team. Don't post a video without that waiver. And from the people that provides the quotes or the comments. However, there are going to be circumstances where a waiver may not be practical, especially when you're dealing with still photos. If your clients, or you, if you may be dealing with it, if you're choosing photos to post on social media, my number one recommendation is to post videos where no one is identifiable. So when you saw me taking pictures for the first hour, you may not have known that. That's good, because you shouldn't be on any of the photos. Basically, you're not going to be identifiable. Always see the back of your heads. The standard is, can a reasonable person identify who you are? And a reasonable person means not somebody who knows you closely, not your significant others, not your closest friends, who may be able to, oh, that's so-and-so's back of the head. But can I, or can anybody else here identify who you are? But let's face it, your clients are going to want to show photos of people enjoying their events, winning nice prizes, drinking, dancing, eating, being merry. Frankly, that connects better with people. I mean, those definitely make nicer photos. If you're going to take pictures and show it off on social media, be direct about your intentions. State outright that you will take pictures and that attendance and registration at the event is consent to use their likeness on social media and in promotional materials, particularly if you're dealing with faces. Tell your attendees that if they do not want their photo taken, you can either attend the event, practical, maybe not practical, or to let the photographer know not to take the picture. Post the social media agreement and registration materials, event brochures, and event programs. Signs at the registration desk, anywhere where you think it is appropriate. Place these social media platforms on these notices to make it look more like a promotion. And invite your attendees to follow or even interact, and maybe even to share their own photos. But just remember that if you're sharing a photo, it's no longer yours. That's why it's called sharing. A little note about children. Placing children on photo or video streams can create some visceral reactions from the users on your social media platforms. If you are a company that caters to children, like a daycare center, or maybe you're doing a moon bounce or something like that, that's one thing. But my general advice is to keep minors out of social media, photos, and video promotions that you're doing. Especially if their parents are not around. There is a body of law, I'm alerted to you, called the Children's Online Privacy Protection Act, which creates a special set of permissions that you need to be aware of if you're going to post content submitted by minors, defined as under age 13, including photos, videos, and geotags. Geotags are the place and time of your photos. So if your organization deals with children and children's events, please be aware of this act, which is administered by the FTC, Federal Trade Commission. Let's talk about accounts. When it comes to ownership, let's do a little case to get you thinking. There's this woman named Linda Eagle. She has a LinkedIn page. I believe it's linkedin.com/in/Linda Eagle. This is an actual LinkedIn profile. It is still there. And she had this LinkedIn account. And she gets hired by a company called EdCom to be the CEO of this company. Well, CEOs are busy people. Fine. So she delegates the account, managing the account to a few of the company's employees. She gives them password access, essentially. It all goes great, everything's happy, and then maybe about a year or two later, she gets fired. The company decides to change the password on her account, essentially locking her out, and changes the profile from Linda Eagle to the new CEO. So now you have the situation of linkedin.com/in/Linda Eagle, but it goes to a completely different person. Yes, we have a problem. This woman is now out of her account. So what does she do? Raise your hand if you know the answer. She sues. Yes, she sues. Very good. So basically, make a long story short, the court held EdCom liable under unauthorized use of a name, invasion of privacy by misappropriation of identity, and misappropriation of publicity because it took over the account and replaced the content with the other CEO's information. But here's a key point. Ms. Eagle recovered nothing. She could not prove damages, essentially. Because, and I forgot to tell you this, she went through the LinkedIn process of, hey, my account's been hacked, and essentially LinkedIn returned the account access to her 2 weeks later. So, that's why she couldn't necessarily prove damages. So here's a lesson. If your client or your company wants to control such an online profile, you need to have a policy requiring such a profile. This company had nothing, essentially. You have to invest time, you have to invest resources, you have to invest money into managing such a profile. When you do that, the party you contract with, you're contracting with the social media platform, not the employee. Because you have to think about it. When you have a social media profile, the contract is between you and Facebook, LinkedIn, whomever. It's not the company. So if the company wants to maintain such a profile, the contract has to be between the company and the social media platform. So EdCom did none of this, and essentially EdCom lost. Here's another example. PhoneDog versus Kravitz. So this guy named Noah Kravitz, yes, this is a Twitter account, and yes, it still exists. I have seen it myself. It's pretty interesting. So PhoneDog hires this guy named Noah Kravitz, and Noah, wisely thinking, well, I'll start a Twitter account. So he gets the handle PhoneDog_Noah, and he promotes his company activities. Well, people start following him, but eventually he quits his job at PhoneDog, and let's face it, as PhoneDog was no longer part of his identity, he wanted to change his identity. All right, fine. So he changes his name, just like Twitter allows you, to @Noah Kravitz. But he keeps his followers that are made with the company. PhoneDog sues, claiming that all the followers are proprietary information. Well, PhoneDog failed to allege how Kravitz continuing to use the Twitter account in his own name disrupted the purported relationships between PhoneDog, not a party between Kravitz and Twitter, and the Twitter users, or how it resulted in economic harm. Two essential elements for these claims. So the major problem was PhoneDog did not allege that it had an employment agreement, so there probably was none, or a confidentiality agreement with Kravitz on how to use the Twitter. And that the followers were proprietary and confidential information. Therefore, they lost the case. So the lesson here is, a friend list or a follower list is not a trade secret if your policies don't say so. And frankly, how would a friend list or a follower list be secret unless the account says so, particularly if this stuff is public? Let's recap our lessons. Make sure your personal and professional pages stay separate, particularly for employees. If your client wants to own their social media presence, they need to develop it on their own work time using the resources at work. Your employees are more than welcome to invite their friends into their professional page that you developed. Finally, insist your clients define on what is the employer's and what is the employee's social media properties. Establish pages clearly marking your brands. Proclaim, don't disclaim your brands. Make it clear in your social media presence is how the person is interacting in the social media world. The less ambiguity you have, the better. When I say do not be afraid of transition, I mean set out a clear policy or checklist when someone is transitioning in or transitioning out of your companies. Make sure the departing employee announces they're leaving, inviting his or her followers or friends to follow them on their personal page if they want to keep in touch personally, and to follow their successor if they want to keep in touch with company events. Have your clients' other employees welcome that person to the company on their social media to give that person followers as a jump start. Now for some more examples. How many people here remember Denise Helms? Okay, I would expect that. When I gave this speech to social media professionals, she is a seminal case. She is like, everybody knew who she was. Let me jog your memory. So President Obama won in 2012. The next day she goes on to Twitter and says, I don't like how this president won, blah, 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 maybe somebody should kill him. Are we beginning to get some details? Jogging a little memory here? Yes, that's who she is. Well, of course, something like that is going to go viral, right? So it went viral. And when stuff goes viral, people put two and two together. Somebody figured out that she scooped ice cream at the Cold Stone Creamery in Sacramento. Guess who had a problem? Yes, Cold Stone. Fortunately, Cold Stone was able to get out of this problem as they were able to fire Helms. She violated that part of the U.S. code that said, don't threaten to assassinate the president. You know, the Secret Service called, they were knocking on her door. I mean, if you threaten a federal official, in any case, yes, we have something called Federal Protective Services. They will knock on your door. And let me tell you, I met them. They're not people you can beat up. They're pretty intimidating people. So, yes. For Cold Stone, it was an open and shut case because there was a clause in her employment contract that said, don't violate the law. Great. But when I gave this presentation about a month and a half ago to some social media professionals, somebody asked, well, hey, freedom of speech, right? Well, not necessarily, because think about this. Cold Stone's not the government, right? Cold Stone's a private company. And then the employment is at will. Remember that, you can be fired for any reason or no reason at all. And then finally, and this is probably what did it for her unrepentant attitude, she did not apologize. And the disruption on business operations, meaning all the people threatening to boycott, yes, that stuff happens. That's what pretty much did her in. And of course, the scrutiny from the media, the NAACP, everybody else, that was enough to justify the firing. But other times, other nasty words in social media may not be as easy for you to handle. Take a look at my example on the right. How many of you have attended a baseball game? All right, particularly the Nats, they have the president's race, right? You all know Abe and Ted and Bill and all those characters. Well, in Pittsburgh, they don't race presidents, they race pierogies. Pierogies are a very prominent meat that they have in Pittsburgh. Apparently, I'm told they're very good. So one of the guys in here, I don't know if it was this one, or this one, but he made a little comment on social media criticizing the Pirates trade that they made as making their baseball franchise worse. Well, these aren't the Pittsburgh Pirates of today, which are very good, but these are the Pittsburgh Pirates of a couple years ago. 20 years of losing. losing and more losing. So, frustrated fan, I understand. The pierogi was fired, of course, but he had to be rehired 2 days later because there's a small problem. He determined that the pierogi was not fired in accordance with team procedures. The Pirates were lucky, even though he was fired, because as soon as he was fired, there was a minor league baseball franchise about 20 minutes down the road that was willing to give him a job. Well, the Pirates basically rehired him and gave him a nice, basically worked everything out. But here's the lesson. If you do not have language in your employment or social media policies about this sort of stuff, you'll be in for a wild ride and employing one of us. Good for us, not great for the clients. They'll be doing their part to alleviate the lawyer employment crisis, right? A little bit about moderation. So when I did my initial presentation introducing our whole social media policy last year, one of my board members came up to me and was like, hey, your entire presentation violates the First Amendment. So I was talking social media, moderation, all that stuff, government agency, everything you said violates free speech, freedom of speech. I asked her, well, how could that be? And she replied, don't people have freedom of speech, and deleting those comments, wouldn't that be illegal government censorship? Well, I looked it up. And the answer to that question is not necessarily. Yes, in the private sector you have more leeway to moderate comments on social media. But, even so, government agencies have the ability to moderate based on the relevancy of the content. That means all those work-at-home schemes, those body enhancement products, those meet people ads, all that annoying stuff, that still can get deleted, as long as you indicate that in your policy. However, a government agency has to make a policy with those speech considerations in mind. But think about this. Even if you're in the private sector, deleting all those negative comments or suggestive comments reeks of a bad business practice. Part of a good customer service is being able to resolve conflicts, or at least attempting to do so. So I advise you to tell your clients, if you have a negative comment, consider putting down in response, we're sorry that you had this experience. Could you please email us or contact us to give us more details about what happened? That'll give your client the appearance of dealing with the problems in their company as opposed to just sweeping them under the rug. Plus, accurate or not, your customer base may think that the freedom of speech means I can say what I want, where I want, when I want, and how I want, even if it offends the other person. We all know that's not true, right? But given that, I urge you to preview the government documents I previously talked about, as they may provide clues on how to handle negative comments. Right here, I just want to highlight again the link to the government policies and the considerations. If you look on this site, there are checklists. There are policy checklists and there are legal checklists that you may want to consider when creating or modifying a social media policy. Just a small note, if your clients are government contractors doing business with the government, they may be subject to advertising regulations. Those still apply in the social media context. Be careful when your posts are speaking for the government. You probably shouldn't do that, at least without consulting the government agency you're dealing with first. Consider meeting with them, consider looking at their policies to make sure that your social media policy, when particularly talking about the matters that deal with the government agency, make sure that they're aligned and that you have a process that you can deal with whenever you have to moderate a post about that sort of post. Let's talk a little bit about some legal aspects. We've discussed extensively about who owns what and who can publish something. Remember, don't oblige your clients or tell them not to oblige themselves to contracts on social media. As we all know from the bar exam, you can make a contract orally in Virginia, right? Remember that? Well, you do that on social media, not only is it oral, but it's written. There's written proof. So train your social media people about this. Similar to contracts, be careful in how you're interacting with your users and fans. Think about what can be implied as an endorsement, particularly if you're dealing with a government agency or whomever. This may include page likes on Facebook or even follows on another site. It's not how us as the knowledgeable people know and interact with this, but the less knowledgeable person that perceives it, that's where you get in trouble. Like the Walmart example I previously mentioned, consider how social media gets used, put it in your policy. Big reminder. When a comment gets moderated, cite the provisions in your social media policies that discuss why. Don't forget, the more open to the public your moderation policy is, the easier it is for you to defend and justify your policy, especially in court. This means directly stating what is good and what is not good, and even providing examples. Treat subject matter comments with care, considering everything I've said today. You need to deal with accessing data of others in your policies. Government agencies may subpoena you for criminal cases. Maybe a divorce lawyer places a subpoena ducis tecum, meaning come see the lawyer and show up with documents, for those of you that have forgotten, from material on your social media. Don't just blindly hand this stuff over. Figure out if there are people you need to notify, for example, your employees, and when to notify. You may want to know how people are using your social media. Totally understand that, to make sure that your posts are getting better and go to more people. Place something in your policy about analytics. Finally, warn your employees that anything they post on personal pages from work computers is subject to corporate discovery. I can't tell you how many times I was doing my contract attorney work, reading emails from people that I've read about divorces, their marriages, rough drafts of toast with totally inappropriate comments. I had a good time, let's just put it that way. When it comes to your policies, prohibit negative posts on competitor sites such as Yelp and Google. You remember the case Yelp versus Indeed that took place maybe last year? There was this guy who decided to start posting negative comments about his competitors on sites such as Yelp and Google. Well, of course, the company sues, and they try to compel Yelp to disclose the identity of the guy. Well, the court says, yeah, go ahead. So the point is, you're going to get identified if you make a negative comment. So be careful, please. And by the way, this is an update from my speech that I gave a long time ago. The Virginia Court of Appeals has held up this decision. So this law is probably going to stay for a while. Let's acknowledge this up front. You'll never be able to control everything somebody says on social media. Gotta be honest about that. Don't count on it. Your bosses, your clients may want to manage it, but you have to be aware of the legal terms. For example, don't ask for login information for anyone. Do not friend your employees, do not write recommendations on LinkedIn, and do not write into your policies that you cannot talk anything about work and on social media. The National Labor Relations Act defined what is called concerted protected activity. One of the named examples on the NLRB website is 2 or more employees discussing work matters, such as pay, such as work conditions. Be careful with that. Frankly, friending employees can be similarly sketchy territory too. It can create just an unprofessional example and create a possibility of monitoring such concerted protected activity. Regarding recommendations on LinkedIn, this is what I mean. If you fire somebody down the road for poor performance, and in the past you've written this nice, glowing recommendation about how awesome they are on LinkedIn, that's going to be used against you. With login information, it just violates each platform's terms of service. Plus, it's just asking you to get sued, whether you'll win or not. However, you're able to discuss what is out of bounds for disclosure in a confidentiality section. Trade secrets, confidential memos, as long as you name that sort of stuff, you're able to say don't disclose and moderate any posts that disclose such information. You're right, you want the law to be as much of a basis as possible in your policies. After all, if somebody is violating the law on your platforms, you want to be able to have the ability to remove such posts. For example, Millennium Copyright Act protects copyright holders from mass dissemination of copyrighted content. Meaning, for them, if this is disseminated and in mass, their work loses value. Communications Decency Act allows you to moderate posts with nasty language, slander, or completely inappropriate content from your sites. Your overall goal is to make the moderation look completely and soundly based on the law. Your customers, citizens, whoever your users are, feel that their views are legitimate. They probably are. This is why a moderator is such an important person, and the importance grows every day. I'll go a little bit quicker since I'm a little quick on time. Remember about privacy, social media professionals call that control of identity. So you need to be careful about sharing content, taking private stuff and sharing that with the public. If you have a subpoena, make sure that's defined in your social media policies. Consent, please be careful on that. I do notice the Electronic Communications Privacy Act, but that's a 27-year-old law. So they haven't heard of social media back 27 years ago, which would have been 1987. Yeah. Of course, we're still trying to figure out privacy in the law. The Alanis case may provide some light on that. States have been passing laws about that sort of content. We in Virginia have not. We've only talked about giving parents successor rights to a child's social media account if they pass away. When it comes to social media and advertising, a quick rule is this. Anything that applies to email and applies to in person, you just move over to social media. So if you don't think it sounds right in a TV or an email context or a direct print email context, it probably won't fly in social media. If you've ever heard of the CAN-SPAM Act, that's mainly about email, but CAN-SPAM rules also apply to social media. I believe I provided some examples here a little bit later on. But yeah, don't forget to disclose employment relationships. So if somebody is disclosing that they like a certain product and you're paying them to either review a product or to promote a product, that needs to be stated up front, particularly if you're giving them a free sample, that too. A little bit about managing risk. Make sure, the key point of this is make sure your passwords are secure. If you want to know more about passwords and all that stuff, on our professional development series website and Google the SBYLC-PDS, we have some presentations from John Simmet and Sharon Nelson of the tech firm Sensei Enterprises in Fairfax. They definitely talk about people getting hacked and all that fun stuff. My recommendation, don't share your passwords. Sounds like common sense, but we get in a little pinch and something needs to happen on an email. Yeah, feel free. This is my password. I trust you. Don't forget to use these fun characters and use numbers. Make sure you have somebody who's managing the account who is trustworthy, and yeah, that'll definitely be fun. give you some takeaways from this. Remember, when creating a social media policy, communicate it. Please do that. Please do this regularly. Send annual notices of the policy, review those policies, and remind your employees in annual notices. Devote time in your company orientations to training on this policy. While this may be common sense to you, we've all had those moments where we lapse in social media. And if you're interested in this sort of stuff, please create Google alerts on social media law, social media, whatever, so that you can keep up with the trends in this law. I provided a lot of information today, I know. This is a tough presentation to keep under an hour. However, consider these philosophies. Share with us your plan. Let us know how you do things, from how you use the platforms to how you interact with us. Second, make sure you have a plan on who owns what that comes across your pages. And then this includes content with releases and with copyright issues, along with who owns what accounts and how these accounts are administered. With moderation, explicitly state what gets moderated and how it will get moderated. Do not forget to provide examples. And then finally, use the law as a basis for moderation when you need to, in addition to corporate policies, whatever. Finally, be aware of the law and how it deals with such special situations, such as with minors, advertising, and in some cases, speech. So I have time for maybe one question, so please fire away. Melissa, you're going to ask a tough question? Okay, let's see what happens.
Earlier in the presentation, you were talking about what happens when employees push on other websites and they have to have their employer name on the, like, under their profile picture.
Mm-hmm.
How do you reconcile a policy that prevents them from embarrassing you with their personal right to make a comment in the first place?
If it's a government situation, that's a little bit different from in a private situation, in a private sector situation, because of the employment at will. So, you know, if you're in a private sector, you say don't make posts that are tirades or whatever like that. You can put that in the employment contract, put that in all the materials. With government, it gets a little bit trickier because of the free speech considerations. I'll have to look at the particular free speech considerations if you want to know more about a specific situation. So, anyone else? Well then, I think we've wrapped up. Thank you very much, and I'll be here all day if you think of anything a little bit later.